In the previous lessons, we referred to certain forms of gender-based violence, including sexual harassment and female genital mutilation. In this class, we will cover a special crime committed against women, femicide. After referring to its overall context of discrimination and violence, we will define it and describe its prevalence, classify it, and mention some criticism leveled against it. The United Nations Convention for the Elimination of All Forms of Discrimination Against Women, or CEDAW, defines discrimination as any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on the basis of equality of men and women, of human rights and fundamental freedoms, in the political, economic, social, cultural, civil, or any other field. Similarly, the phenomenon of violence against women is defined in the Belém do Pará Inter-American Convention as any act or conduct based on gender which causes death or physical, sexual, or psychological harm or suffering to women, whether in the public or the private sphere. Therefore, the special legal category of femicide must be studied relying on such legal concepts as they provide the normative and sociological framework within which femicide operates. In this context, UN Women's first Executive Director, Michelle Bachelet, called in 2013 to strengthen justice systems, provide training to the police and judges to eliminate stereotyping and prejudices towards women, improve support services to survivors and families, and dedicate planning and budgeting to preventing violence against women and girls. She also stressed the importance of the engagement by men in the efforts to stop violence against women. The World Health Organization defines femicide as the intentional murder of women because they are women. Femicide is a neologism that conflates homicide, from the Latin homo or man, and cedere, to hack or to kill. Femicide joins the Latin word for woman, femina, with that of murder, thus resulting femicide. It is worth noting that some feminist activists argue that the precise concept should be that of feminicide rather than femicide, as the former would reflect the misogynist intent behind the act, whereas femicide may amount to any female death, regardless of the motivation behind it. Yet, the expression femicide is more widespread in the literature and legal systems. It has been criminalized in Argentina, Bolivia, Chile, Colombia, Costa Rica, Ecuador, El Salvador, Guatemala, Honduras, Nicaragua, and Sweden. Every year, approximately 66,000 women are murdered worldwide. The highest rates of femicide are in El Salvador, Jamaica, Guatemala, South Africa, and Russia. Femicides are perpetrated through an array of gruesome means, including stoning, stabbing, beating, burning, beheading, hanging, throat slashing, acid throwing, shooting, and strangulation. The case of Ciudad Juárez in Mexico is particularly infamous. Between 1993 and 2005, reportedly more than 300 women were murdered in that city, with some other 4,000 having disappeared during the same period. The case caught the attention of the CEDAW Committee in 2002, pursuant to accusations made by several NGOs. It eventually was brought before the Inter-American Commission on Human Rights that same year, and then submitted to the Inter-American Court of Human Rights in 2007. This court declared in its 2009 ruling on the cotton field case that Mexico had breached its obligations under the American Convention on Human Rights. It stated that in Ciudad Juárez, there existed a situation of structural discrimination against women who were killed as such and because they had become more competitive than men in the local cotton industry. It is said that the term femicide was first coined to refer to these murders in Ciudad Juárez, although feminists already used it in the 1970s. In a 2012 report, the UN Special Rapporteur on Violence Against Women, Rashida Manjoo, identified the following kinds of femicide: intimate partner femicide, women suffering 77% of domestic murders worldwide; femicide due to accusations of witchcraft; honor killings to cleanse the reputation of the victim's family after adultery, pregnancy, and even rape; femicides committed during armed conflicts; dowry-related femicides whenever the bride's dowry is deemed insufficient. A particularly heinous form of dowry killing is that of bride burning, known in countries such as India, Pakistan, and Nepal, whereby a domestic accident is feigned, resulting in the burning alive of a woman whose family did not pay a sufficient dowry. Indigenous women's femicides. Femicide as the result of organized crime and human trafficking. Femicide due to sexual orientation or gender identity. And other forms of femicide, such as the burning alive of widows next to their deceased husbands, and female infanticide. The UN Human Rights Council welcomed the Special Rapporteur's report and recommended states to enhance access to justice by women and ending impunity. The creation of femicide as a legal category has prompted some criticism from different quarters. For one, advocates of cultural diversity argue that criminalizing the killing of women, regardless of the culture they take place in, may amount to a Western imposition upon other cultures. Yet, it is important to recall the opinion of the UN Commission on the Status of Women. The Commission urges states to strongly condemn all forms of violence against women and girls and to refrain from invoking any custom, tradition, or religious consideration to avoid their obligations with respect to its elimination as set out in the Declaration on the Elimination of Violence Against Women. Also, some criminal law experts regret the criminalization of femicide as an invention driven by the zeal of feminist encroachments within the legal realm. Some feminist activists, in turn, denounce the concept femicide as yet another device aimed at imposing unwarranted differences between men and women, whereby only men would be able to suffer homicide proper, whereas women would be held as objects worthy of special protection through femicide. Thus, they propose the alternate term gendercide to signify a murder on account of the victim's gender, whether male or female. Now, besides the fact that femicide has been used in the common law tradition since at least the 19th century, we must not forget that all branches of the law, including criminal law, are instruments designed to satisfy human needs, and not fetishistic symbols that cannot be altered or evolved. In the case of the murder of women just because they are women, we are not dealing with plain homicides. Much as in the case of genocide, we do not talk about aggregate individual homicides, but of the intent to destroy a human group as such. The law needs to protect individuals that are, indeed, in a special position of vulnerability within the household, and even within certain cultures. If of old a man's house has been considered his castle, the fact is that every castle had its king, its servants, and its dungeon, where women may be left in a particularly vulnerable position, always on death row, always in fear of execution, as pointed out by the UN Special Rapporteur. Thus, the criminalization of femicide should be viewed as a special measure aimed at securing substantive equality between men and women, as we will explain in a further lesson devoted to such measures. Thank you for your attention. Please visit mookchile.com and watch our next class.